Well, good afternoon or good morning to those of you who are on the West Coast. We appreciate you joining us today for another ERISA Attorney Talk hosted by Qualified Plan Advisors. We appreciate you being here today, and we know that a lot of you are heavily involved with other year-end tasks, whether it be, health and welfare open enrollment meetings, year-end financials, et cetera, and have a lot on your plate. So our goal today is to work through a pretty large number of retirement plan related topics so that you can walk away from this feeling like, okay, I've got a pretty good sense of what I need to know right now about what's happening with respect to the law and the retirement plan environment. And then perhaps you'll walk away also with two or three things that you say, hey, the next time that we have one of our committee meetings, we should talk about this because this is something that others are doing across the country, and we should decide whether it might be good for our organization. Your panel today is going to include the top three on this list. So as always, you have Scott Liggett, our Director of ERISA Oversight from our Overland Park, Kansas office, Chuck Smith, our Nebraska Retirement Practice Leader in our Omaha office, and I'm Matthew Eichman, our Retirement Practice Leader. We don't have Mike Smoots with us today. Mike is out seeing a client and has traveled and had this kind of on his calendar for some time. And when he asked if he should move that, we said, of course you shouldn't. You should go run your client meeting. So we'll miss Mike today, but feel like we'll capture some of his sentiments as well. And as I mentioned, we're going to go through a number of topics today. We want to talk about the new fiduciary proposal. I'm going to give you some updates around plan forfeitures, and then dive a little bit into what's developed and what's happening on the legislative front. Talk about these long-term part-time employee rules, and then also Secure 2.0. We know that continues to be on your mind, and I think there continues to be so much misinformation out in the marketplace that we're going to help you to really hone in on what you need to know now, and then perhaps what you should start discussing in the upcoming quarters. Scott Liggett's going to walk through some thoughts about target date funds and really highlight the fact that as those have continued to gain additional utilization across the country, we want to ensure that fiduciaries are giving them a proportionate amount of their additional attention. We're going to expand a little bit more on developing financial wellness trends, and we're going to go around the horn here and share some of our additional thoughts from a hot topics perspective. So I'll tell you, here's where we want to start. And a lot of times, I prefer to start a webinar with some sort of story, but then the Department of Labor came along on Halloween and gave us the new fiduciary rule proposal, and that really serves as our introduction today. Because when the Department of Labor puts out a rule attempting to define what it means to be a fiduciary, for a group of ERISA attorneys, this is a highlight of the year, right? Maybe not the most exciting, maybe not the best part of our entire year, but certainly something that's noteworthy and merits a lot of discussion. And, some of you probably have read a fair amount about this. Some of you maybe haven't read about it, but you saw headlines related to junk fees, and then a strong push perhaps from those who are opponents of this new proposal. So we thought we would start with this very simple question. That is, what do we really need to know about the Department of Labor's new fiduciary rule proposal? Now, some of you may remember that there's this long and twisting road from 2009 and 2011 and 12 and 2016 and into 2017. Well, let's leave all that in the past and let's instead focus on the present. And what we saw here is that on the morning of Halloween, the White House put out a fact sheet announcing that they were indeed going to publish this proposed regulation later that day. And what we knew even ahead of time here is that the language in the proposal was not going to say, this is the, quote, new fiduciary rule, end quote. Instead, the title of this was going to relate to retirement security. It will define what it means to be an investment advice fiduciary. That is, one who is serving as a fiduciary when providing investment advice. But the context here, the way in which the Department of Labor wants us to think about this proposal is that it is really concerned with the retirement security of your employees and employees all across the country. So that proposal was released later that day. It's since been published in the Federal Register. If you've had the fortune to read write-ups, perhaps ours or others, or you've been through part of the regulation, you know that on the one hand, there's a fair amount in there. On the other hand, we can really boil it down to some high-level details. And we put out a fiduciary news alert around this that attempts to summarize the entire rule just in one page. But I want to highlight a few things for you here, and then I'm going to ask Chuck and Scott to share some of their opinions as well. More than anything, what this would do is it would recognize that there are a number of situations right now where an investment professional provides advice to a potential client or a client. And in those situations, the Department of Labor's perspective is that those individuals, those investors, your employees, perhaps you as an individual investor, feel like you're in a position of confidence. You feel like you're in a position where you should be able to trust that that person providing you advice is looking out for you. But in fact, under current law, the fiduciary umbrella is not broad enough to cover those situations. So under this new proposal, the umbrella would get wider. The umbrella would cover more contexts, more types of advice, and in particular, it would cover a recommendation to you or to one of your employees to take a rollover from your plan, to take a distribution from your plan, how to invest the proceeds from that rollover or from that distribution, and even to tell you don't take a rollover, oh, don't take a distribution. So that's really the goal here, is that the Department of Labor is concerned that these people across our entire country are getting advice, they're getting it from professionals, and those professionals are able to put their own interests first and not the interests of the participants. So what's going to happen next is that we have this, we're already, about a quarter of the way into this 60-day comment period. And the Department of Labor intends to work pretty aggressively here, I believe. They want to move through that comment period. They want to have the hearings that are a part of this review period. They want to publish a final regulation, and they'd like to get it on the books before the election next November. And one of the reasons for that is that we think it's fairly clear that if a Republican wins the White House next November, that a Republican would likely abandon this rule. And certainly if it were still in proposed status, it's even easier to just walk away from the proposal. And we also expect we'll see numerous court challenges. So I guess I'd stop right there. And Scott Liggett, why don't you share with us first kind of your perspective on this proposal?
Thanks, Matthew. My view is, yes, there's probably going to be a lot of twists and turns and different directions this proposal takes, and towards either becoming law or whatever the next iteration is. But my personal view is I do appreciate that efforts continue, legislative and regulatory efforts continue to help bring a fiduciary protection umbrella to employees that have worked very hard, plan participants that have worked very hard to accumulate their retirement savings, and then when they leave, when they retire, and go out from the umbrella, the fiduciary umbrella that their plan sponsor has worked so very hard to put in place, that there's attempts being made to bring that same sort of level of protection to them after they leave employment or leave, being a plan participant. So I'm encouraged by that. We'll see where it leads us, but I think those efforts, are laudable and should continue regardless of what the outcome is.
Thanks, Scott. And Chuck, I know your perspective is that this is certainly going to become law, and it's going to carry with it a great amount of weight, right? Is that your position?
Absolutely. Now, Matthew, you alluded to the long and tortured past that the fiduciary rule has had from 2012 to 2016. And we've gone out to plan sponsors a number of different times and talked to them about a new fiduciary rule. And this is just the latest iteration. And there might be a tendency from plan sponsors to say, okay, I've been down this path before, and it didn't actually end up being a law. In addition, this is something that advisors are dealing with, and they're working with their compliance department to deal with. Maybe you could answer, what does this mean to me as a plan sponsor? How does this impact me if this rule is finalized?
Well, that's a good question, and I'm actually going to acknowledge up front, for any of you as plan sponsors, it's possible that this rule will never become law, or if it does become law, it will only be law for a short period of time. And also, if it becomes law and stays law, that it could directly impact you as a fiduciary very little, if at all. So what I've chosen to do, Chuck, as I think about this, is I want to focus on the rationale behind it. I want to focus on, as Scott said, kind of what the Department of Labor is seeking to protect against here. You know, we had a lunch and learn in Fayetteville, Arkansas last week, and we did a little bit of a quiz with the group before we started our presentation. And one of the questions on that quiz asked the audience, an investment professional who provides advice to your employees is serving as a fiduciary when he or she gives which of the following recommendations? Choice A was take a rollover. Choice B was take a distribution. Choice C was how to invest the proceeds. Choice D was none of the above, which is the right answer. And choice E was all of the above, which is what almost everybody chose. And so what that said to me is it's common for us to overestimate the amount of protection employees have when they leave. And so as an employer, what I would be looking to do is to not be too caught up in whether this will become a rule, whether this will become a law, whether this will become binding for 6 months or for a year or for 10 years. But instead, as we think about the process when our longtime employees leave the organization, how can we best protect them? How can we best look out for them? And if you can look at that news alert down on the very bottom left corner of the page here, you'll see how we close that news alert. If you find people objecting to this rule, it's likely because they feel they cannot hit their profit margins if their advice is required to put the investor's interests first. Run the other way from those objectors. Keep them away from your employees. And so, Chuck, I think that's probably what I'll take from this is if I'm an employer, I want my people working as much as possible with those who are comfortable being fiduciaries. Now, let's transition a little bit. And let's talk about something that impacts plans probably far more than everybody even realizes, and that's the notion of forfeitures. And Chuck, you know, I want to turn it over to you to kind of lead us through these questions and other related topics. You know, like, is there a deadline for using plan forfeitures as we approach the end of the year here? And then I guess, like, I mean, does it really even matter, like, when those are used? And maybe you can help to talk us through that.
Yeah, absolutely. As of today, there is not an official deadline for when a plan has to use forfeitures, which, as a reminder, that's when any participant who has who's subject to a vesting schedule on their employer contributions leaves prior to fulfilling that. Those unvested amounts go into a forfeiture account. And as I mentioned, today there is no deadline for the use of those. However, the IRS has made it very clear their opinion prior to this was that forfeitures needed to be used in the year in which they occurred. So many plan sponsors were following that rule, but others were just ignoring it completely. So what we've got now is the IRS issued proposed regulations back in February, giving us an actual timeline. And unlike the fiduciary rules that Matthew just mentioned, everyone's in favor of these. This may seem harsh to put a deadline on it, but it's far better than the situation we are in currently, where it's kind of fuzzy on when forfeitures need to be used. And in the regulations, importantly, they specified the 3 uses for forfeitures, reaffirmed how plans can use those, and they're listed here. They can use them to pay plan expenses, reduce employer contributions, or reallocate them to participant accounts. Now, there's a transition rule here at the very bottom. So the regulation would go into effect beginning next year. But if you've got forfeitures that you've been hoarding for the last few years, they're going to be treated as though they became forfeitures on January 1. So you would actually have until December 31 of 2025 to use those forfeitures for one of those 3 purposes. Now, why it's important, I'm going to transition to the next slide. You know, when you're dealing with forfeitures, you might have read in the news, there's been a number of lawsuits involving forfeitures recently. This Demo, if I'm saying that correctly, versus Thermo Fisher Scientific is one of 4 lawsuits by the same law firm that are alleging a breach of fiduciary duty for a plan sponsor when they decided to use forfeitures to offset an employer contribution, which, as I said, is one of those 3 enumerated uses for forfeitures, instead of using them to reduce expenses, reduce the fees of the plan. And why is that important? Well, in this plan, the fees were paid by participants. So in effect, it was a decision to do something that benefited the company rather than that would have benefited participants. And that's the cause of action here, is a breach of fiduciary duty for not putting the interests of participants ahead of the company. Sounds like a slam dunk. However, most plan documents are not written to give the plan's administrator, the committee, the actual authority to use those forfeitures. So at the very top here, I've included a sample plan document. We don't have the provision that's included in the lawsuit plan, but this is something that I pulled from a plan document that's very common across the industry. And you'll notice here that it says the employer shall allocate and use the forfeitures either to reduce expenses, an additional contribution, or to offset an employer contribution. And I emphasize here that it's saying the employer has this discretion. The employer shall use it for one of these purposes. And so it's very important to make this distinction here between an employer who does not normally have a fiduciary duty and his only obligation is to the shareholders of the company, and the plan committee or the plan administrator or the employer wearing that plan administrator hat who does have a duty to the plan participants. And so when the employer is acting in a non-fiduciary capacity, it can make a decision of whether or not to use those to benefit the participants or benefit the company. In fact, at the same time these lawsuits were coming out, the Department of Labor issued an advisory opinion, 2023-01A, in which they specifically said it was involving Citibank, and Citibank was making some fee payments on behalf of the plan to investment managers. And the Department of Labor came out and said very clearly that plan sponsor decisions on whether they will pay any fees that could otherwise appropriately be paid by the plan, those are settler decisions. Basically, they are not fiduciary decisions. They're not subject to the fiduciary standards. So bottom line is, I don't think these lawsuits are going to go very far. I think the consensus is both from the IRS perspective and the Department of Labor that when an employer makes that decision, it is not doing so in a fiduciary capacity.
All right, thank you, Chuck. That's helpful. So, I think if nothing else, it feels to me like the recommendations that you have down here at the bottom are something that people ought to follow without regard probably to the nature of the litigation, right? It just seems like you've given us 3 important steps here that
Exactly.
all sponsors should follow.
Yeah, I think the important thing to take away here is that distinction between the plan sponsor, the settler, and the plan administrator. And if you follow those 3 recommendations, first, look at your plan document to make sure that A, gives you those 3 uses that you can use for forfeitures, that it's the employer that has that designation. And then secondly, when you're in your committee meetings, don't make that the place where you make decisions on use forfeitures. You can document in your committee meeting minutes that the employer made that decision, but be very particular on how that decision was made.
All right, thank you, Chuck. Let's transition now to talk a little bit about the long-term part-time employee rules. And just by way of background, it was easy to forget about this rule because it was in Secure 1.0, which was passed in 2019, right before the pandemic kind of, took away our attention, and we ended up focusing more on the CARES Act than we did the original Secure Act. But there was a rule in the Secure 1.0 that essentially reflected Congress's preference that more people gain the opportunity to save into an employer-sponsored plan. So just to be clear here, Congress didn't say in Secure 1.0, hey, you need to give the match to more people. Hey, you need to give more employer contributions to more of your people. What it said is, when somebody has worked for you for a reasonable length of time and on a part-time basis, they should have the right to be able to save into your plan. They should have the right to be able to make deferrals. And so what that rule said is that these long-term part-time employees, those who were credited with at least 500 hours in 3 consecutive years, will gain eligibility. And because the first year we counted those was 2021, this means that if you started counting your long-term part-time employees' hours in 21, and you counted them in 22, and again in 23, we could be about 6 weeks from the first class of these LTPT employees gaining access to your plans. Now, just fast forward a little bit, Secure 2.0 is actually going to shorten that period from 3 years to 2. So just know that when you get later in 2024 and you're thinking about whether you have any long-term part-time employees who should become eligible on the first day of 2025, there will be a 2-year look back and not a 3-year look back. But I think these are pretty big, potentially big rules. And Scott and Chuck, I know that both of you have worked through these with clients a fair amount recently, and I wonder if you could share just some experiences, some anecdotal experiences perhaps on how some of your clients are handling those. Scott Leggett, why don't you start and share a couple of the experiences that you've had?
Sure, thanks. Yeah, recently, and actually in the last 30 days, one of our clients has a number of part-time, historically has had a number of part-time employees, and they were concerned about tracking those hours, the 500-hour limit, and keeping accounting for those hours. And so the decision they made was to really allow anyone to defer. In other words, there was no exclusions. They let anyone that was an employee, age 21, a few other eligibility requirements, but anyone could defer. Now, I will say in their case, they were already a large enough employer. They were subject to an independent audit, so the number of people with an account balance was not going to impact their audit requirement. But they chose the route of, instead of worrying about tracking these hours year in, year out, because that was going to be an issue for them, they chose to allow eligibility for everyone. Had another client who actually has decided to allow part-time employees, all part-time employees, to defer as well as match on those deferrals, more from a competitive standpoint of trying to keep their part-time employment filled. They have issues trying to find enough people, quite honestly. And so two different approaches, two different rationales, but that's some experiences I've come across here in the last 30 to 60 days.
How about you, Chuck? What are you seeing?
Yeah, I've had a lot of employers take that first step as well. Ever since this came out over the last couple of years, we've been working with employers to reduce that eligibility for deferrals. Interestingly, when this first came out, as you mentioned, Secure 1.0, one of the concerns about allowing for early eligibility for deferrals was for top-heavy plans, that they would allow additional employees to be subject to that top-heavy contribution, which, for everyone who's not familiar with it, that's an additional 3% contribution to every employee if you have, quote, a a top-heavy plan. However, the Secure 2.0 did include a new provision that says anyone that you allow into the plan early and be more generous, like Scott was saying his employers are, we're not going to include those in for the top-heavy test, and they do not have to receive the 3% top-heavy contribution. So that's been a great change in this last year. So I've got a couple employers who are now going to do that exact same thing as Scott. And then the second thing is you can still exclude employees by classification. It just can't be part-time, seasonable, or temporary. So if there's a group of employees, whether it's interns or I was literally this morning on a call where they're clerical workers, we're a group that are typically part-time that they may not want to include. You can still use a classification to exclude employees, and they would not be subject to this long-term part-time employee rule.
So I think for anybody listening, to kind of tie a bow around this, if you're already either not counting any hours and providing immediate eligibility, or you already have an hours counting rule that for some reason is 500 hours or less, this won't be a great departure for you. But to the extent this will be different, number one, I think a lot of you are probably already on top of it. I've been pleasantly surprised with how proactive the record keepers and the document providers have been. But if this is news to you, if you've got questions, please reach out to us. We've got a news alert on this that can help to walk you through the steps, kind of the what now steps. You can see some of those over here on the left. But again, this should be something that I think most of you are probably fairly prepared for. But to the extent you have any questions at all, now's the time to reach out, because it's a good kind of 6-week period here to get everything in place for January 1 of 2024. Okay, so guys, that makes for a natural transition as we move over into Secure 2.0. And what I want to highlight first, before we get some input from each of you around what we think are the most important sections or the things that you're talking about most with clients, I want everybody to listen very carefully as we walk through what is required what is not required, and what things remain unsettled. Because I think for plan sponsors sitting here on November 14th, November 15th, the middle of the month, looking out ahead saying, oh my gosh, do I have everything I need to have when the new year hits? We're going to help with that specific question. So this is really where we should start. Does Secure 2.0 require the provisions that you see in front of you? Does it require automatic enrollment, automatic escalation, matching student loan debt repayments, HCE catch-up contributions to be made as Roth, after-tax employer contributions, or in-plan emergency savings account? The short answer for all of you is no. So as you think about right now, or you think about the January 1st of 2024, you are not required to have any of these in place when that new year starts. Now, I mentioned that there's a longer answer. So for example, the HCE catch-up contributions made as Roth, that will become effective in 2026, and automatic enrollment and automatic escalation will be required in 2025 for any new plans that were created on December 29 of 2022 or later. But if you had a pre-existing plan, those rules will not become applicable to you. So we know those aren't required. So what we really want to focus on is like, what do you need to know right now? And so as we tick through these 6 items, I'm going to hit these really quickly and then get some feedback from Chuck and Scott on which of these are gaining the most traction or engendering the most conversation with their clients. So first of all, as I mentioned, that Roth catch-up contribution, that's delayed to 2026. We already celebrated that with big parties, right? When the IRS came out with that news, it said, hey, we're going to tap the brakes on this. We're going to give you 2 more years to get ready. As many of you know, the required minimum distribution age, which used to be 70.5 for the longest time, moved to 72 with the first Secure Act. It's now 73. Any of you who have within your plan a mandatory cash out limit of $5,000, that's that rule that says, hey, if somebody leaves with a balance less than $5,000, you can force out that distribution either directly to them or via automatic rollover to an automatic rollover IRA. You now have the ability to increase that cap. And this is something, if you're at 5,000, if you've already taken action with your record keeper, hey, that's great. But if you haven't, you might want to reach out to your record keeper or reach out to your advisor and say, hey, help me through this. We want to find out, is your record keeper taking the approach that anybody who is at 5,000 will be deemed to move to 7,000 unless you tell them otherwise, or do you have to opt into that increase? So that just merits a conversation with your record keeper. The hardship substantiation rules, they really aren't new. They're just stronger and more clearly reflected in statute. It's consistent with the guidance the IRS was already applying, but now we know from a congressional perspective that employees, the participants, can self-substantiate their hardships. As I mentioned, the automatic enrollment, automatic escalation, that's only for plans that were created December 29 of 2022 or later. And then finally, and I know Chuck, you've got some thoughts on this, how the narrow definition of participant for Form 5500 purposes will be meaningful. But in addition to that, for your disclosure requirements, you're going to find some relaxed standards for making all of your disclosures. So really, guys, that's what we think people ought to know now. But what are you talking about with your clients? Not even what you see here on the screen per se. We can work through some of this, but what are the items that are that you're most interested in? Chuck, we'll start with you.
Yeah, obviously all those required provisions, we're having those discussions with employers, but the one for me that I'm really looking forward to the guidance on is the student loans match contributions, and having a lot of discussions with employers about the ability to make a matching contribution based on student loan payments. And maybe it's the wannabe financial advisor or the financial planner in me that working with employers who understand that employees are paying back their student debt after that hiatus, and there are going to be some struggles, and we want to encourage student loan debt payment at the same time as allowing them to participate and become vested in the retirement plan. So that's top of the list for me, and waiting for that additional guidance and waiting for some kind of for employers to start adopting this in 2024, so that perhaps I'll have a number of my clients adopting it, say in 2025.
How about you, Scott?
A couple of things have kind of dominated discussions lately along these lines. One is anything Roth related. And what I mean by that is, as you mentioned, Matthew, the the catch-up contribution, the mandatory Roth treatment of that being delayed, so that will come to pass before too long, but also the opportunities for employers to make their matching contribution or an employer contribution as Roth. I too am looking for, guidance on that. It's been a big discussion point with a lot of clients, as well as, interestingly, you'd mentioned the automatic enrollment and automatic escalation. While not required, I'm having more and more discussions with clients that currently do not have those provisions, and they are plans that have been in existence, so they're not required to do that. But I'm getting more plan sponsors looking at possibly adding those features to help with, sometimes recurring discrimination testing issues, or the ability to get employee contributions deferrals up more with peer groups, and to try to be a polite nudge for some people. So those are the areas that discussions permeate right now.
Yeah, and then I think the last thing that I would say on Secure 2.0, I think you all can tell from Chuck, Scott, and me that there's really not a lot for you to have to do right now. The IRS grab bag guidance will help to confirm how some of this will work, and I think that'll really get the record keepers working a little bit more fervently as they decide, what they'll support and what they won't support. But I'd like you to maybe just give a little bit of thought to the bottom point on the slide here, and that is for you to think about how you define and perhaps redefine the value proposition provided by your organization's retirement program. And some of you have heard me talk about this recently, that about a decade ago, if you were to describe your organization's 401k plan, or maybe even a 403b plan, you probably would say, yes, we have one. Secondly, you'd say, here's our employer contribution, and then maybe not much else. And over the last decade, the number of features, the number of bells and whistles that we're adding to these plans has really expanded the ability for you to sell all these various features. And if you go down the road of matching student loan debt repayments, as Chuck has advocated for, or you add the employer Roth capability, or you put an emergency savings account within the plan, that's an additional step that you're taking towards saying to your people, hey, we're really listening to what you want, and we've adapted, and we're providing you that within your benefit program. So give that a little bit of thought. Take a look at your employee handbook. Take a look at the flyers that you take to job fairs. Take a look at what's on your website when you describe your benefits, and think about a way to redefine the value proposition of what your company's bringing to the table. Now, Scott, I know that target date funds are something where we continue to see an increased utilization across the country. But one of the experiences that I've had with clients is that despite the increased number of assets, despite the increased percentage of plan assets involved in target date funds, I don't know that they necessarily get a proportionate amount of attention from a fiduciary perspective. And I think you're going to talk through here a few considerations that fiduciaries should keep in mind when they think about their target date funds.
Yeah, I agree, Matthew, and put a few slides together here. And for some, if you're new to retirement plans, or haven't had that responsibility much in the past, you may be thinking, well, target dates have been around a long time. Aren't they just on autopilot? We have a lot of assets in our plan in target dates. Isn't it just an automatic feature? And in fact, the popularity of target dates really go back to the Pension Protection Act in 2006, which allowed for automatic enrollment. And at the time, plan sponsors, understandably, were looking for, if they are going to be withholding money out of employee paychecks, it needed to be deposited, invested somewhere. And so there were some fiduciary safe harbors that were created, QDIAs, qualifying default investment alternatives. And so just a little history lesson here. There are 4 types of permissible QDIAs. The first being target dates, which we're going to talk about, which take into account, it's a product that takes into account age or individual's retirement date. The next would be an investment service, like a managed account, where an account would be put together and take into consideration allocations based on age and retirement dates. The third would be a mix of investments factoring in the characteristics of the group of employees as a whole, like a balance fund. So those are the three types. And understandably, target dates just kind of took over. Many companies came to market, record keepers, investment companies, insurance companies, investment managers came to the market with lots of different variations of target date funds, and that has taken over. So as the next slide points out, where we're at now is we have nearly $3 trillion in the target date market, and over half of active participants have invested their monies in target date funds. So we are at this very large concentration of retirement plan money in target date funds, and understandably, you've followed enough of our events to know we like talking about the litigation risks. And as the next slide highlights, litigation follows the money, and just various headlines here. So the litigation landscape has evolved into the target date world, and for a lot of people that may be somewhat of a surprise, or they may be, well, how could that happen? So what should I be doing? So it generates the conversation, right? What should I be doing as a plan sponsor? So you may want to re-examine or evaluate, if you haven't had an opportunity to do so, what is the plan sponsor's goal in offering the target date funds, right? Target date funds become more conservative over time. So you hear the term glide path used. Basically, what is the pace in which that particular fund becomes more conservative over time? And they're categorized as being to retirement. So does that move to a more conservative asset mix? Does that stop at retirement, or does that continue through a retirement date? So to or through glide path. The third point is very important. What is the cost and what are the options for the target dates that you're using? That next bullet point points out that CITs, collective investment trusts, make up now 47%, really half of the target date strategies at the end of last year, and are projected to become the most popular target date vehicle. So if you're currently using target date funds, are you using a mutual fund share class, or do you have a CIT share class? That's, again, something you want to take a look at. Are your employees receiving education regarding the plan's target dates? You're offering them. They're probably your plan's QDIA, but what level of education are employees receiving to make sure that they are utilizing them correctly and that they understand what the purpose of them are? And then lastly, this is just something that I've been looking at more closely, is you might want to learn more about your evolving QDIA options. We talked about the three different ones: target date funds, a balanced fund, or a managed account. And there's becoming more and more options for what's called a hybrid QDIA, which in essence, early on in someone's career, at their early ages, they are in a target date fund, and then at a particular age, whether it's 45, 50, or 55, they would be automatically moved over to a managed account solution. So it's really combining two different types of QDIs into one. All right, so that's a lot of questions. So how, what type of assistance and resources do you have to help you with that? And that I want to, tip my cap to our Houston office, QPA's Houston office. They began this type of reporting several years ago, and now we use it company-wide. So twice a year, QPA prepares a target date deep dive where we look at, and I gave one example here of one of the criteria that we look at, evaluating different target date suites. And if many of you have probably worked with your QPA advisor to go through this in the past, if you're a QPA client and you haven't had an opportunity to have this sort of analysis done or walk through with your decision makers, please let us know. Or if you use some other target date fund that you'd like to have, an analysis prepared, please let us know that as well. Then lastly, what I want to leave you with is the Department of Labor has, for over 10 years, has had a checklist of things to look at. They call it their tips checklist, and all the different things that we've been talking about here, looking at the different target dates, looking at their fees, their investment mix, looking at the employee communications and education that's done, all the different checklists here that we can walk you through. Your QPA team can walk you through. And then you'll notice the example here we give, that could be signed and dated. And this is some good documentation for your auditors, for anyone coming in saying, what level of evaluation have you taken for your target date? So again, just a reminder, I think too often we get lulled into a sense of security that, well, the money's in a target date fund, our participants are in a target date fund, so all is well. So that just needs to be revisited from time to time.
And Scott, I appreciate you walking through that deep dive report and this checklist. The commentary I would share with everybody is that all the target date fund manufacturers across the country, they've done a pretty nice job of developing some sort of analyzer tool. And inevitably what happens is, even if the tool isn't engineered to best support their approach, the output certainly is intended to tell a relatively good story about either the process or the outcomes or both. And what I like about this approach is that it's a non-proprietary approach and actually focuses a lot on this at the end. And that is really following the Department of Labor's process. Rather than following the process recommended by Fund Manager A or Fund Manager B or Fund Manager C, the Department of Labor seems to have jurisdiction over this. And so I think to the extent that we can use this checklist at the end of the process, I think our clients will feel safer as a result. Okay, so as we wrap up today, I want to highlight one quick point in response to this question, and then I want to get some feedback from the two of you around, kind of going around the horn, the other things that are on your mind. For those of you who have been listening and talking with us this entire year, you know that for a group of ERISA attorneys, we probably talk about financial wellness much more than you would expect. And I think that's because we've gained an appreciation for, not just having safe fiduciary clients, but having good fiduciary clients. And a big part of that is focusing on the effectiveness of the plans that you have, both from a retirement readiness perspective and a broader financial wellness perspective. And I will tell you, the number one trend that we're seeing across the entire country, and certainly with our clients, is that more and more people want to have those one-on-one conversations. So we're moving away from some of the old group education approach and saying people want a personal conversation. Now, in the slides behind this one, I have some of the statistics that kind of support that notion, and we've included those in a practice perspectives piece. If you're a client of ours, when you look at your reviews for this quarter, you'll see that right up front. So I'm not going to stay on those, but this is a preview of what that practice perspectives piece looks like. And then we've got all the data behind that reflecting that employees want and need help with their finance. They expect financial wellness from their employers. They want to be able to meet with an advisor, coach, or consultant. They'll stay with an employer longer if they have access to a financial wellness program. And finally, employers, they feel a sense of responsibility for wellness, but also they see the benefits for their organization. So that's something I think we'll continue to see and hear more of as we move into 2024. And as we close up here, I'd like to hear from each of you, 60 to 90 seconds, what are the other things that are on your mind? Chuck, let's start with you.
Absolutely. First, for 10 seconds to let you know that I completely agree on the financial wellness. Matthew and I are in the same office, and as ERISA attorneys, I the other day joked, I know how we can make all of our retirement plans bulletproof. That's just terminate them all. And it was a joke emphasizing that the point of a retirement plan is not to be compliant. It's to benefit the employees and make a someplace that some people want to work. And so that's why I have joined the bandwagon on financial wellness. But the things I'm talking about now, one thing is, as Matthew mentioned, the 100 participants for your 5,500 to avoid the audit. Do that. You've got 45 days left to get that done. And then the second thing that I think we'll be talking about more in the future is cybersecurity. For those of you that are QPA clients, you might remember in 2021, we went out and audited most of the major record keepers to kind of figure out their cybersecurity practices. I think that needs a reboot, especially in the wake of AI. We think of all the positives it can do for us in the workforce, and we're a little scared of what it can take over. One of those things is the retirement plan space. I mean, a lot of record keepers have voice authentication processes, and AI can now mask that. So we really need to go back out and work with, you need to go back out, work with your QPA advisor to vet record keeping and make sure they're keeping up with the latest in cybersecurity.
Thanks, Chuck. How about you, Scott?
A couple of things. I think the biggest evolution, to chime in on financial wellness is in the last several years, I've seen a shift from the plan sponsors I work with when we talk about financial wellness programs. The discussion had historically been, well, our employees might be interested in doing something like that, or might be interested in participating in that, to really, our employees need this. And that's been a pretty quick evolution, and I think a welcomed approach to that. As far as topics that come to mind that we're seeing right now is, if any of you followed the United Auto Workers discussions, during their time with their strike and the various labor issues, pensions came up, the defined benefit pension plan approach. And while that didn't become a piece of the new collective bargaining agreement, more and more conversations are revolving around pensionizing 401k plans. And so I think income in retirement, the ability to help participants, and as they become retirees, converting their hard-earned 401k accounts into some sort of income in retirement stream, I think is going to become more and more prevalent. More and more options are going to come to the market, and so plan sponsors need to get up to speed and work with their advisors to see what's available to best help their people.
All right, thanks, Scott. And the thing on my mind is, speaking of the desire people have to be in person or to have one-on-one conversations, we want to make sure that you have our 2024 Fiduciary Summit on your calendar. This is our last webinar of the year, and I really look forward to the opportunity to see you in person, to be together in person, to have our small discussion groups, whether you're a golfer and not a golfer, to spend the evening just getting to know people in the industry, talking about similar challenges they may be facing and how they're attacking those. So to the extent you've already snapped the QR code here and you're registered, I appreciate that. If you haven't, if you do that right now, you can be registered in less than 2 minutes. There's no cost, but at least it'll get it on your calendar, and we would love to have all of you there. So thanks so much to Chuck and Scott for all of your prep work and your commentary today. And thanks to everybody for joining us. We really appreciate it. And there are a number of items on here where, we said as we work through, if you have questions, reach out and let us know. And I want to reiterate that we'd be happy to help any of you with any questions you might have. We hope that you have a wonderful rest of your day, and thanks again for joining us today.